capabilities, particularly against financial crimes. But before I come to the provision of this short bill, I want to say a few words by way of introduction. After 10 years of connivance by the previous government, when the scourge of drug trafficking was allowed to seep deep into the fabric of our society, the need for our law enforcement agencies to work more effectively together has never been greater. Yet, the whole nation knows why was the Financial Crimes Commission Act passed. It wasn't passed, Mr. Deputy Speaker, to intensify the combat, against the money launderers, or the fraudsters, or the corrupt gangsters who infect public life in our country. It was passed to protect or pursue those whom the last government ordained. Some people were completely protected, some people were harassed. That is why this Financial Commission Act was passed. A good example is why else? Why else would they exclude the vital role of the constitutionally independent Director of Public Prosecutions, an offense against which the last government shamefully mounted attack after attack after attack? The Financial Crimes Commission was not created to work hand in hand with other agencies, but to be controlled by one political party in its own interest. That is why it was passed. Contrary to them, Mr. Deputy Speaker, we in this government are introducing new legislation to rebuild the capacity of our law enforcement agencies to act effectively, independently, and objectively. As the President's speech has already foreshadowed, we intend to establish a new precious national crime agency. As we embark upon this essential amendment today, it is critical to remember an overreaching aim, which is empowering our legislative authorities and eventually transitioning towards establishing a comprehensive national crime agency, which would be modeled on the international best practices, notably in the United Kingdom. In this regard, Mauritius has already started to work closely with the British authorities. This is provided in our strategic partnership framework established earlier this year in the context of the Chagos Treaty. This is already there. The United Kingdom has indicated its willingness to provide substantial support for the establishment of our National Crime Agency, including providing expert, technical, and strategic advice, legislative guidance, and organizational expertise. This collaboration will significantly enhance our capabilities to effectively tackle financial crime and also other serious crimes. The possibility of joint investigations as outlined in the newly introduced Section 58A of the Financial Crimes Commission Act mark a significant step towards this vision. This joint endeavor is being advised by a team of international expert investigators embedded with the police, who are helping to bring new techniques and approaches and sharper focus, urgency and coherence to important investigations. Experience has shown, Mr. Deputy Speaker, that it is not always desirable or efficient to separate responsibility for the investigation of offences artificially. It is often the case that offences for the investigation of which the police are responsible are also closely connected to financial crimes, which at the moment falls within the responsibility of the Financial Crimes Commission. And so these offences are being investigated separately. FCC on one side, the police on the other. In such cases, it is obviously desirable and common sense that the two agencies of the Mauritius Police Force and the Financial Crimes Commission should work closely together and in certain circumstances should have the capability of mounting a joint investigation into particular suspects or criminal groups. These criminals, Mr. Deputy Speaker, they do not look at the statute. They do not see which compartments are going to affect them. The fragmented approach between the Financial Crime Commission and the police has often resulted in unnecessary duplication. And you know, Mr. Deputy Speaker, when there are duplication, you'll find that there are leakages as well. Somebody has spoken to somebody else. Unnecessary duplication, but more importantly, delays in investigations and ultimately prosecutions. At this stage, we need urgently to reinforce the capabilities of the police and the FCC to provide a workable framework in order not to jeopardize inquiries which are ongoing or become necessary. Criminal networks, they exploit these procedural gaps, and this leads to the undermining of public trust and confidence in our system. With the proposed amendments, we will ensure clearer, structured cooperation in three distinct and practical scenarios. Firstly, in the course of an ongoing police investigation, should evidence arise indicating financial crimes, which often does, that normally would fall within the remit of the Financial Crimes Commission. So you can see, Mr. Deputy Speaker, two separate investigations are started. The police now have a clear mandate not only to inform the Commission, but also to directly collaborate with them. This will ensure a swift and coordinated response from the very beginning, maximizing the potential of successful prosecutions. Secondly, in the instances where the Financial Crimes Commission is already investigating an offense, and the police, in the meantime, uncover related criminal activities, joint operations can now be properly initiated upon request. This coordinated approach ensures a comprehensive, consistent, and unified investigative efforts across the different law enforcement bodies. The third scenario provides what we can call flexibility. Should both the police and the Financial Crimes Commission agree that a joint investigation would be beneficial, they will be empowered to initiate a coordinated effort, pooling resources, pooling intelligence, and special skills. Such fluid cooperation will greatly enhance the effectiveness, speed, and depth of investigative processes, leaving no space for the criminals to evade justice. These interim measures, Mr. Deputy Speaker, pending the fully fledged NCA bill, do not in any way impede the work of the FCC or the work of the police. It creates a possible collaboration to ensure a more efficient process, given the ramifications that can exist in large-scale inquiries. Not only has the CP, Commissioner of Police, the obligation to inform the Commission, but then the onus is squarely on the two investigative agencies to work together. This amendment is intended to do just that. It is carefully designed to promote cooperation and, where necessary, joint investigations between the police and the Financial Crimes Commission, while respecting the current statutory independence of each agency. And I must explain some of the technical details of the bill, Mr. Deputy Speaker. For example, Clause 4 introduces a new Section 58A1, I will move an amendment later on, into the Financial Crimes Commission Act. And Clause 2 makes Section 56 of the Act, which gives the exclusive power to the Financial Crimes Commission to investigate all money laundering, fraud, and corruption, be subject to the new Section 58A. In other words, for the collaboration between the two. It envisages three possible separate situations. First, Clause 58A1 deals with the situation in which the police are investigating or they intend to investigate an offense under the General Criminal Code or the penal provision. While they're doing this, they may become aware that the offense they investigated investigating or intend to investigate is connected to an offense of fraud or corruption under the Financial Crimes Commission, which is not already under investigation by the FCC. The new Section 58A2 requires the police to keep the FCC fully informed of the progress of the investigation and provides that the FCC may require the police to investigate the fraud and corruption offense jointly. However, Clause 58A also provides that the police must serve notice, cannot just do so, it must serve notice on the FCC that they are doing this. The new Section 58A2 requires the police to keep the FCC fully informed of the progress of the investigation and provides that the FCC may require the police to investigate jointly with them the offense of fraud or corruption. Nothing, Mr. Deputy Speaker, in Section 58A2 prevents the FCC from doing so at any time during the police investigation. That is deliberate because there may well be cases in which the FCC only becomes aware at some later stage that of circumstances are there that make it desirable that it should also be involved because there are cases of financial crimes. Section 58A3 provides for the second situation, that is, the police investigating or intend to investigate an offense which appears to them to be related to an offense of fraud or corruption under the FCC Act, which is already under investigation by the FCC. In those circumstances, the Commissioner of Police may require the FCC to investigate the fraud or corruption offense jointly with the police. Mr. Deputy Speaker, in each of these two cases, the amendment gives both the police and the FCC the right to opt for a joint investigation without the need for actual consenting. They can do so if they feel there is a need for it. This reflects the fact that in each of these two cases, both law enforcement agencies will have a direct and substantial interest in the investigation and might justifiably be that they will be impeded in their statutory functions. Obviously, related inquiries were to be pursued separately. However, they are not, as I said earlier, they are not obliged to require such a joint investigation. The proposed amendments leave open the possibility that they may choose to ensure appropriate coordination between the inquiries by informal consultation and cooperation under the new Section 58(5), and they agreed for a joint investigation. As I say, Mr. Deputy Speaker, it is only if either agency believes that from its perspective a joint investigation would be necessary and advantageous, and if the other disagreed that it would be necessary to exercise the statutory options of the new Section 58A1 and 4 creates. Whether or not the police or the FCC reach that conclusion would depend obviously on the circumstances and individual facts of the relevant inquiries. However, if one or the other agency believes strongly that only close and detailed joint planning and decision-making implied by a joint investigation would successfully lead to a resolution of the inquiry, it could then insist, only then, that a joint investigation be undertaken. In those circumstances, Clause 58A4 requires each to put in place suitable arrangements for the efficient joint conduct of the investigation. This reflects the fact that in each of those cases, both law enforcement agencies will have a direct and substantial interest in the investigation, which are very often not only serious but very complex inquiries. However, they are not obliged, as I said earlier, for a joint investigation. The proposed amendments leave open that possibility, as I explained. Finally, as already intimated, Clause 58A5 provides for the third situation. It gives to the Commissioner of Police and the Financial Crimes Commission the legal basis to agree for joint investigations when it is plainly of mutual benefit and for the public interest. At present, there is no express legal basis for formal joint investigation between the police and the FCC. The government believes it is desirable the law on such important matter should be express and unambiguous. Indeed, it is reasonably to be expected and very much to be hoped that the new Section 58A5 will be the normal route to which joint investigations are established. This bill, Mr. Deputy Speaker, is intended to promote greater and more efficient collaboration and ensure the close and cooperative functioning of the two most important law enforcement and investigative agencies in Mauritius. This will be an important preparatory step for the formation of the Mauritius National Crime Agency, and I cannot emphasize the seminal importance for Mauritius of making a success for that new institution. In conclusion, Mr. Deputy Speaker, sir, these amendments are fundamental to our unwavering commitment to transparent government, efficient administration of justice, and securing a safe and prosperous Mauritius, a future for Mauritius. They form, in fact, the very bedrock upon which we will build our future National Crime Agency, ensuring Mauritius remains vigilant and resilient against financial and organized crime. For the time being, it enhances cooperation between the two investigative agencies, which will eventually report to the Director of Public Prosecutions, without in any way hindering or sidelining one or the other agency. It is, in fact, the DPP which will decide whether to prosecute or not to prosecute. For these reasons, I strongly commend the bill to the House.
Honourable Leader of the Opposition.
Thank you, Mr. Deputy Speaker. Sir, Monsieur le Président, j'ai entre mes mains la liste des orateurs et l'ordre des intervenants pour le FCCB. Et je constate malheureusement qu'on déroge d'une des traditions établies pour les débats dans cette chambre.
Honourable Leader of the Opposition. Honourable Leader of the Opposition, please. Let me. Your name is on the list to address the bill before the House. I have before me a list of the list of those who are going to intervene, and we are going to go according to that list. It has been always the tradition of this House that the chair goes according to the list which is submitted to him or her. The chair does not go behind the shield to see how this list is prepared and how it has come to that. We have come to that list. We'll go according to that list. I will not allow any intervention or any remark made to that list. If you have any queries, you know, you are a seasoned politician, you have been Deputy Speaker, your colleagues have been Speaker, you know what to do. So we'll proceed with the list. No.
May I please raise to the attention of the Chair on a point of order?
Which order? Which point of order?
Yes, the point of order concerns the rules of debate, Mr. Deputy Speaker, with regards to...
Which rule of order?
On the rules of debate, look
Which
at...
one?
You have to check the rules of debate.
No.
And the point of order is as follows, Mr. Deputy Speaker.
The rule...
Okay.
No, Honourable Duval, please. I've already said... Yes, the rule of debate, sir, I have to catch the eye. I know the rule of debate. But sit down, please. Can I sit? I am on my feet now. Please sit down. Please sit down. The rule of debate is about catching the eyes of an interviewer. The rule of debate deals about catching the eyes of an interviewer. Now, the tradition in this House, you have been here long, I have been here for more than 25 years now. It has always been the tradition that a list is submitted to the chair and we go according to the list. We have a whip, a chief whip from the government, and a whip from the opposition. It is for you to take your responsibility. The list is before me and we are going to go according to that list. Thank you, Honourable Leader of the Opposition. You have... No, I am not going. Please, I am on my feet. I am on my feet. Please. No, I am on my feet. Please. I am on my feet. Let me sit. I am on my feet. Order. We are. No. cross-talking, please. I am on my feet. We are going to address the bill before the House, as per the list submitted to me. I am not going to entertain any standing order or any remarks made on the list. If you feel I am arbitrary, you know what to do. You have been a speaker, you know. If you want to challenge my ruling, you know what to do. Okay? Let's go back. No, let's go back to the bill. Honorable Leader of the Opposition, you have the floor.
Well, I'll raise it when I speak.
Monsieur le Président, je voulais faire le point parce que dois-je comprendre que c'est mon collègue, laissez-moi terminer, dois-je comprendre que c'est mon collègue, l'honorable Adrien Duval, qui aura refuté les arguments du leader de l'opposition à l'intérieur de cette Chambre?
He doesn't have to refute. He has to address on the bill. If he wants to address on the bill, he address on the bill, and you are being invited now.
C'est pourquoi je dis qu'on déroge d'une des traditions les plus importantes lors des débats à l'intérieur de cette Chambre, Monsieur le Président.
Order, listen to the bill.
Ouais, Marie a proposé de démocratie.
Mr. Deputy Speaker, sir, first of all, allow me to begin my intervention by referring, and the Honorable Prime Minister made reference to that, to paragraph 10 of the government program 2025-2029, and I quote, "In view of the recent serious challenges to the rule of law and the role of enforcement agencies, government will take immediate measures to ensure that they operate in a totally independent and transparent manner." It goes on, "Government will repeal the Financial Crimes Commission Act and will set up a national crime agency which will be better equipped to deal more effectively with financial and other serious crimes. The agency will not impinge on the prosecutorial powers of the DPP, but will ensure that an investigation is carried out independently, objectively, and effectively." End of quote. Monsieur le Président, 7 mois après, le Financial Crime Commission Act est toujours vivant et rien à l'horizon concernant cette nouvelle agence, c'est-à-dire le National Crime Agency, alors que dans le discours programme, le gouvernement parlait de immediate measures, mais non seulement de immediate measures, mais aussi that investigations are carried out independently and objectively. Monsieur le Président, avec cet amendement à l'ordre du jour, l'indépendance de la Financial Crimes Commission est grandement remise en question à travers l'ingérence de la police et le pouvoir du commissaire de police sur les affaires de la FCC. Ce n'est plus la FCC qui décidera s'il faut ouvrir une enquête ou pas, ce sera à la police. Et pas plus tard, Monsieur le Président, que le 19 juin, le Premier ministre, en répondant à une PNQ élaborée sur les mesures qui sont mises en place par le gouvernement pour réduire les problèmes liés à la situation de law and order dans le pays, et il affirmait ceci, je cite, "We have already started implementing those measures. We are setting up, as I mentioned, I think I did not mention the National Crime Agency. It is not just an agency, it will comprise specialist divisions with skilled investigators, including foreign ones. At the same time, the National Prosecution Service would be under the responsibility of the Director of Public Prosecutions." Encore une fois, un engagement du Premier ministre, mais rien. L'honorable Premier ministre va plus loin en ce qui concerne la police et le bureau du DPP. Il ajoute qu'il faut éviter le clash entre le commissaire de police et le DPP. Voilà ce qu'il avait dit, Monsieur le Président. You remember the clash between the Commissioner of Police and the DPP, we will stop this. Now, with the prosecution service as it is the DPP who will decide who will be prosecuted, not the police. The police can give, and he said that earlier, the police can give their views, but it will be for the DPP to decide who will be prosecuted or not. Mais aujourd'hui, on nous présente un projet de loi qui va créer, Monsieur le Président, une crise institutionnelle entre la police et la FCC. On a voté il y a quelque temps de cela le Public Inquiry Act et nous savions tous que la commission d'enquête qui existait avant était indépendante. Mais aujourd'hui, on nous propose une mainmise de la police sur une autre institution indépendante, en l'occurrence la FCC, Monsieur le Président. Mon deuxième point, Monsieur le Président, est par rapport à l'effectif de la FCC et de la police. Ces derniers temps, il y a eu plusieurs démissions au sein de la FCC. Et c'est vrai qu'il y a un manque de ressources humaines. Mais la police aussi est déjà surmenée avec la situation de law and order dans le pays. Et elle est aussi en manque d'effectifs. Et lors d'un PMQT, c'est-à-dire le 4 mars dernier, le Premier ministre avait fait comprendre à la Chambre qu'il existe plus de 3000 postes vacants au sein de la force policière. Alors nous nous retrouvons avec deux institutions qui ont des problèmes de ressources humaines et on leur donne des responsabilités additionnelles. Mon autre point, Monsieur le Président, est par rapport aux qualifications des agents de police pour entamer des enquêtes liées au blanchiment d'argent ou de fraude. Monsieur le Président, ce projet de loi est le deuxième amendement proposé au Financial Crimes Commission Act sous ce gouvernement. Un certain amateurisme de la part de ce gouvernement, Monsieur le Président, et de mémoire, je n'ai pas connaissance de deux amendements apportés à une même législation en 8 mois. Et le comble, Monsieur le Président, au niveau de la FCC, on a toujours un officer in charge. Lors des débats, Monsieur le Président, sur la FCC Act en 2023, c'est-à-dire décembre 2023, l'actuel Deputy Prime Minister avait parlé des décisions fondamentales à être prises pour le bon fonctionnement de cette institution et que la nomination du directeur général de la FCC en faisait partie de ces décisions fondamentales. Eh bien, il me semble qu'aujourd'hui, Monsieur le Président, ce n'est plus le cas. Le présent projet de loi propose tout simplement des enquêtes conjointes entre la FCC et la police. Monsieur le Président, c'est du déjà vu. Comme après les élections de 2005, quand l'actuel Premier ministre avait présenté 2 amendements à la POCA et avait revu la façon de nommer le directeur de l'ICAC pour avoir une mainmise sur cette institution. Aujourd'hui, 20 ans plus tard, la FCC est amendée dans les mêmes conditions et à travers ces amendements, on nous propose cette fois-ci de permettre au commissaire de police, le bras droit du Premier ministre, de s'immiscer dans les affaires d'une institution indépendante avec pour seule et unique mission de combattre la corruption. Je dois dire que l'honorable Ritesh Ramphul nous avait déjà annoncé la couleur en 2023 lors de son intervention et je cite ce qu'il avait dit. Faites attention, les rênes de ce monstre seront à présent entre les mains de ce gouvernement. Dieu saura ce qui se passera quand ce monstre changera de maître. Maintenant, on sait le nouveau maître de la FCC sera le commissaire de police. Le commissaire de police, selon la clause 58A1 de ce projet de loi, aura le privilège et je pèse mes mots, Monsieur le Président, le privilège de démarrer une enquête sous la FCC Act. Est-ce que vous vous rendez compte de ce que vous êtes en train de faire? Donc, Monsieur le Président, demain, si l'institution censée être indépendante, qu'est la FCC, qui a trouvé qu'il n'y a pas lieu d'avoir une enquête sur un cas en particulier, parce qu'il ne semble pas y avoir d'offense commise, le commissaire de police, lui, peut démarrer son enquête et procéder à des arrestations et mettre des charges provisoires comme bon lui semble. Il n'aura tout simplement qu'à notifier la commission et dire que l'honorable Mohamed nous sortait cette perle en 2023, et je cite, I said that no Labour Party government is entitled to have a law like that. No MMM government no alliance government should have this despicable act in their hands. It should be thrown out. It should be kicked out when we undertake to throw it out. Eh bien non, Monsieur le Président. Qu'est-ce qu'on fait aujourd'hui? On l'améliore. Et maintenant, le comble, c'est que les amendements à la FCC Act ouvrent une grande porte sur les dérives. Et ne vous fiez pas aux autres sections qui suivent. C'est simplement du eyewash. Le plus important, c'est de permettre au commissaire de police de faire ses propres enquêtes sur des cas de corruption allégués, et c'est extrêmement dangereux. Après le démantèlement, Monsieur le Président, de l'État-providence, nous assistons aujourd'hui au démantèlement de la lutte contre la corruption et de faire de la FCC un instrument politique. Maintenant, on peut parler de monstre, Monsieur l'honorable Poutine. Dommage que vous n'allez pas respecter votre engagement pris dans cette même Assemblée en 2023 pour évoquer cette loi. Vous aviez tous, sans exception, fait le procès de cette loi. Ce gouvernement, Monsieur le Président, avait même annoncé, je l'ai dit un peu plus tôt, une nouvelle institution. Mais on attend venir. Cette annonce, Monsieur le Président, a créé un sentiment d'incertitude à la FCC. Depuis, ils sont plusieurs à avoir démissionné ou pris leur retraite anticipée. Ces officiers sont sous pression et voilà que désormais, ils auront un nouveau chef en la personne du commissaire de police, l'homme de confiance de l'actuel Premier ministre. Cet amendement, Monsieur le Président, est dangereux et je ne comprends pas comment certains, au sein de l'alliance gouvernementale, vont s'associer à ce projet de loi. Pourquoi un tel amendement, Monsieur le Président, alors que la FCC va être remplacée par une autre institution? Malheureusement, ce gouvernement prend des décisions catastrophiques et ce projet de loi en fait partie. J'en ai terminé, Monsieur le Président.
Right. Honorable Duval. Honorable Duval.
Yes, thank you. Mr. Deputy Speaker, first of all, let me say that it is the first time that a debate is done wherein, in Parliament, members are being requested to speak after one another.
Don't try to have a second bite. Sit down. Sit down. Don't try to come back to that issue. Don't try to have a second bite of the cherry. I have already given my ruling. If you want to intervene on this bill, you intervene. If you don't want, I am going to call the next point. So you have the floor. You have the floor for the next 15 minutes.
We say, Mr. Deputy Speaker, that when it came to voting amendments to the FCC bill earlier this year, the FCC bill, I was then allowed to refute ministers to speak after the
Understand this bill.
Right? Second thing.
Come to this bill.
Yeah. No, I'm just saying I will table it. Same for all the other interventions, the special allowance bill, etc. That was not the practice.
You are coming back again to the same issue. Honorable Duval. Honorable Duval, sit down, sit down. Sit down. Order, sit down. Sit down. Order. I'm making a last appeal to you. You stand up and you address the House on this bill. If you don't want to address on this bill, I have no alternative, but I'll go to call the next orator according to that list.
Okay, I will take the other places. Mr. Deputy Speaker, the first issue lies in the manner in which this amendment is being brought. The manner in which this amendment is being brought. First question, why was the Parliament Committee on the FCC not apprised of these amendments, when we know that the law provides at section 129 of the FCC Act, subsection 1, and section 131, 1E, subsection 3, that matters pertaining to reforms ought to be brought before the committee. This was the case when the amendments were brought to introduce the threshold of 500,000 or less, which are to be now exclusively undertaken by the Commissioner of Police. But that was not the case for these new amendments. So the first question, why have we bypassed the Parliamentary Committee? Why have we bypassed the law which provides that it ought to have been brought there first, ought to then have been made by a report, recommendations to this Parliament, to government, to bring legislative amendments. So we take note that the Parliamentary Committee now has become, well, chacun tirera la conclusion de ce que le comité parlementaire qui régit la FCC est devenu, une farce. Deuxièmement, why the urgency? Why bring an amendment under a certificate of urgency, which has only been introduced to Cabinet on Friday, and therefore has been given to honourable members a few days ago, and we are being asked now to ponder on this urgent matter. An urgent matter, and this brings me to the core of the issue, an urgent matter which was not so urgent, firstly, at the time of the budget, and at the time of bringing the other amendments which I spoke about the threshold, the introduction of a threshold to unclog. I will come to it. The first thing first, the spirit of the law behind the FCC. What was the spirit of the law? It was to have an apex investigative body that had all the means, all the personnel, all the equipment, the surveillance equipment, the special powers under the FCC Act to carry out surveillance, to gather information, to call in investigative bodies, in fact, to co-opt people on its various boards, co-opt people from outside who have specialized knowledge on, for example, financial crime. So it has been given in the law leeway to do whatever it needs to be done so that it can maintain its role as the apex investigative authority. And now this section 58A is now saying we're going to sideline the FCC now. It is no longer going to be an apex because by definition apex sits at the top, and now we are going to have the FCC, which is going to have basically the same, if not a reduced role, to that of the Commissioner of Police, who now by default will inquire for cases under 500,000, which I understand, which is logical, in fact, Mr. Deputy Speaker, because when you hear the arguments brought, you will understand that the reason why such an amendment was needed was to unclog the machine, the investigative machine of the FCC, to allow it to focus on, of course, on major crime, financial crimes. So then it was decided, it was a good decision, for minor offences to be dealt with by the police. But then also comes the budget 2025-2026, which gives a considerable increase to the budget of the FCC. 38% increase, of course, so that we allow the FCC to go and recruit personnel it needs. In fact, 38% also in staff allowances, staff costs. So the idea in the budget was to allow the FCC to make use of all the arsenals that it has been given. It was a monster, by all means, but still, on paper, it has all the prowess of being an effective apex investigative body. But we increased the budget to 38% for this financial year. Therefore, we tell the FCC, we're giving you more money. We're giving you more money. We are reducing your caseload. We are giving minor offenses to the Commissioner of Police for you to be able to focus on these important investigations that we judge as priorities. But then how do you explain that after all of that, the FCC, by the way, with its whole 415 million rupees, has, don't forget, in-house counsels and attorneys, specialized investigators that have degrees in crime, in investigating financial crimes, that receive overseas training sent at the cost of the taxpayer to make them better, more efficient investigators. This is where the money is supposed to go, where they have surveillance equipment, including putting people on surveillance, tapping, etc. The FCC has that power in its legislation. And there is, of course, the interagency cooperation, where as the apex body, it can call in whoever it wants under Section 58 and hold hearings, and people have to attend. But on the other hand, we have now the police. The police who, don't forget, who is supposed to prevent, detect, and investigate crimes, including the CCID, but who sees its budget in terms of human resources, capacity, being cut by 10%, from 9,431 officers funded for the last financial year, down to 8,550 officers. So on the one hand, we are increasing FCC budget, we're telling them go and recruit. Here we are slashing police persons posted to prevent, detect, and investigate, including the CCID. We're slashing among their ranks, and we are now saying that Section 58A makes sense. How does it make sense? How, when the proliferation of drugs is something which is happening at an unprecedented rate, violent crime is on the rise, insecurity is a growing concern in the heart and the mind of every Mauritian in this country. So therefore, Mr. Deputy Speaker, the police ought to have had other priorities, ought to have put their resources better in places where they ought to have been efficient, more efficient. But let us come to Section 58 now. There are other issues now in terms of, in practice, how it works. We know that the FCC, as the apex investigating authority, was not answerable to anyone, albeit with the amendments that have been brought by this government, which were good amendments. I intervened on those when I was given a proper ranking to intervene after ministers. I did intervene to say that these amendments were in fact meritorious, to give back the DPP the power to take the decision whether to institute prosecutions or not. But then, as still the apex investigating authority, it is now being asked to work in tandem with police in two matters. First, for existing investigations, the police may request to step in. Fair enough, under your amendment. The police, if you'll see, under the Section 58A, subsection 1, where the Commissioner of Police considers it would be in the interest of the efficient conduct of an investigation into any offence under this Act, and that the offence is not already under investigation by the Commission, the police shall investigate into the offence. In fact, I was talking about subsection free. But this subsection, let me make that point now, where a declaration will now be made at the police. The CCID, for example, if it has been assigned the file, en tout cas, les casers, will have the authority and the mandate to open the investigation themselves now for an offense falling under the Financial Crime Act. You look at it, you will see, if the FCC is not investigating it, the Commissioner of Police shall do it. So if a declaration is made at les casers, it can do it at the outset. It would then be for the FCC to ask the Commissioner of Police to step into the inquiry. Les rôles se sont renversés. Now for the rest, I was saying where under subsection 3, the police is investigating where subsection 5, where the Commissioner and the Commissioner of Police agree that it is in the interest of efficient conduct of investigation into an offense under this Act, they shall jointly investigate into the offense, and for that purpose they shall make suitable arrangements. So that will concern ongoing investigations, potentially future investigation opened by the FCC. But the matter remains that under subsection 1, the police will from the outset be eligible, be allowed, be enabled to open the inquiry themselves. It would then be for the FCC, for the Commission, to request that they join in. This is how it's going to happen. So is that not infringing, going against the spirit of the law? And the questions that are being raised are as follows. Will there not be another potential conflict between agencies? I will come to it. But first question, when we're talking of, for example, where will the interviews be conducted? Interviews of accused, of witnesses. Will it be at Eben? Will it be at Kazan? Where will the files be kept? Are there going to be 2 files? Is there going to be 1 file? In which office is it going to be kept? At the Kazan or at the FCC? Who will be recording the statements? These are the questions. And then, Mr. Deputy Speaker,
You've got 3 minutes to go.
the potential conflict under the investigation that is under Section 58. Actually, the FCC, it has to refer the investigation to the Commission to make a report, and then the report is sent to the DPP. But then, now that the Commissioner of Police may investigate as well, is he now going to be able to send himself the recommendation for prosecution to the DPP? To send the file to the DPP from the Commissioner of Police initiatives himself? Or will it go under Section 58? Nothing provides to this. And this brings me to the same conflict that brought this government to introduce the Bail Act, to clarify the powers of the DPP and the Commissioner of Police, where there was, at one point, institutions fighting amongst one another openly, and which was, in fact, a disgrace for our Constitution. But then, we remember, for example, the Honorable Acting Attorney General at the time, my friend Mr. Honorable Shakil Mohammed, was then the one who brought the amendment to the House. And he said, the encroachment blurred the lines between investigation. At that time, he was talking of the DPP and the police. Investigation and prosecution, 2 distinct functions, assigned by the Constitution to test 2 separate authorities. But what he said was more interesting about the police. It led to a toxic situation, one where the police and the apex prosecuting authority were in open conflict, forced into lawsuits against each other, one where public trust in the justice system eroded as citizens questioned on whose orders were the police truly following, one where suspicions of political interference in the detention of citizens being all too justified. That was being said for the Bail Act. I will ask now, government, whether this risk does not arise, where the conflict between the FCC and the Commissioner of Police, where there cannot be another source of open fighting. So
Can you please
Mr.
conclude
Deputy
now,
Speaker, I am concluding now
Thank you.
to say that it is a shame that not more time was given to members of Parliament to look into these amendments, especially since in the past this manner of doing things had been criticized. Earlier this year, members of this House came to apologize when a certificate of urgency was used on another bill introduced to Parliament, where we were saying, we apologize, this is not the way of doing things, but things are urgent. But I must say, Mr. Deputy Speaker, I haven't found any compelling argument till now to justify why this amendment is being brought under this certificate of urgency, having bypassed the Parliamentary Commission, which has been empowered to make recommendations of these sorts to this House. Thank you.
Thank you. Honorable Mr. Wickham.
Thank you, Mr. Deputy Speaker, sir. Mr. Deputy Speaker, sir, the country, the nation, and the generation to come, when reading Hansard, will remember on the 15th of July 2025, when this government brought legislation to render investigation into financial crime more efficient, more effective. The two members of the opposition took position against that law. Why did they take position against that law? Because this law is going to give power to investigate into malversation when they were in government. That is why they are objecting. The honourable leader of the opposition, come and read from our government program and say that we had stated that we'll take immediate measures to ensure that law agencies operate in total independence. What was the first bill that we brought this year? Wasn't it a bill to amend the Financial Crime Commission precisely to give the independence, to restore independence to the Director of Prosecution? Wasn't that fast enough? The leader of the opposition is telling us that we're taking time to bring the bill on the National Crime Agency. We've been here for 7 months, Mr. Deputy Speaker, sir. You know when the Financial Crime Commission, which was voted in 2023, you know when it was announced by the MSM government? In 2015. It took you 8 years. 8 years to come up with the Financial Crime Commission, and now after 8 months, you expect us to come with a new law, and when you're not doing it, you're telling us not procès d'intention. This bill is urgent, Mr. Deputy Speaker, sir, because there are ongoing investigation, there are potential investigation, and the Financial Crime Commission need the support of the police to resolve some of these inquiries. This is the reason why we are coming here. And why are we coming here? The honourable member did not say a word about the Financial Task Force. Honourable members would remember how under the MSM government, the reputation of Mauritius as a financial centre was tainted when the Financial Action Task Force, back on 21st February 2020, placed Mauritius on its grey list as a jurisdiction under increased monitoring. Soon after, the European Commission placed Mauritius on its blacklist of jurisdiction with strategic deficiencies in AML CFT regime. There were serious deficiencies in our anti-money laundering and control of terrorist financial regime. Why? If you look at the official communiqué issued by the FATF in February 2020, one of the main reasons why Mauritius was placed on the grey list was our inability to demonstrate, and I quote, that law enforcement agencies had the capacity to conduct money laundering investigation, including parallel financial investigation and complex cases. We were unable to carry out financial investigation and complex cases. There was a glaring lack of coordination between our law enforcement agencies. Institutions were operating in silos. Critical intelligence was not being shared, and investigations were often delayed, compromised due to overlapping mandates and fragmented efforts. May I remind the honourable member what recommendation 30 of the FATF provides, and I quote, "At least in all cases related to major proceed-generating offences, those designated law enforcement authorities should develop a proactive parallel financial investigation when pursuing money laundering, predicate offences, and terrorism financing." This is what we're doing. We are applying what FATF is telling you to do. Allow parallel investigation. And what did the ESAMLAG, Eastern and Southern African Money Laundering Group, state in his report dated July 2018, which was the basis on which we were grey-listed? At paragraph 6, well, page 7, I read, "Law enforcement agencies do not conduct parallel financial investigation in a majority of cases, and particularly for offences such as drug trafficking, which is a high-risk offence in Mauritius." We were criticized precisely because the police and ICAC then were not doing parallel investigation. And today, when we're going to allow the police and the FSC to conduct parallel investigation, you're telling us that we are démanteler la lutte contre la corruption. ESAMLAG, Mr. Deputy Speaker, sir, noted that the law enforcement agencies, ICAC, now FCC, the CCID, ADSU, and MRA, as well as the FIU, had been working without proper cooperation, coordination, and information sharing among themselves. This resulted in lengthy and ineffective investigation and very low number of convictions. C'est ça le bilan du MSM. 10 ans. How many persons arrested and convicted for fraud and corruption? Mr. Deputy Speaker, sir, with the proposed amendment, there would be a proper cooperation and coordination between the police and the FCC. Where the Commissioner of Police agreed that it would be in the interest of the efficient conduct of the investigation into an offence, they may jointly investigate the offence with the FSC, and when they do so, both FSC and the police will make suitable arrangements for the effective conduct of the joint investigation. It would appear that the Honourable Adrien Duval, who left without listening to what I have to say to the point raised, he seems to have completely overlooked the amendments that have been circulated. In the amendment clearly provides now that it is not going to be a monopoly of the police, or the police taking over the work of the FSC, or the police replacing the FCC as an apex body. No, there will be collaboration. The police may, not the police shall. The police may, and when the police decide to conduct the investigation, they still have to inform the FCC. The FCC can say to the police, okay, let's work together. We'll conduct the investigation together. Let's work on a suitable arrangement for the sharing of information. So it's not that the police is replacing the FCC. The police and the FCC, where necessary, will work together. Now, why is that important, Mr. Deputy Speaker, sir? Let us take an investigation being carried out by the police, là-dessus, into a drug trafficking offense. They are investigating, they are going out, collecting intelligence, arresting people, and then soon they find out that the proceeds of the crime, the money, has been used to buy a yacht, to buy a Raptor, to buy buildings. So during the investigation, there is proceeds of the crime that is identified. So at this point in time, what does the police do? Under the then Prevention of Corruption Act, Section 45, subsection 2 provided, and I quote, where in the course of a police inquiry, it is suspected that an act of corruption or money laundering offense has been committed, and the Commissioner of Police is of opinion that the matter ought to be investigated by the Commission, ICAP, the Commissioner of Police may, notwithstanding SFIAMLA, refer the matter to the Commission for investigation. So under the Prevention of Corruption Act, which preceded the Financial Crime Commission, there was this possibility that in the course of investigation, the police find that an offense may have been committed under another act which falls under ICAP. At that point in time, the police could refer, may refer, and the police could continue doing its investigation. But when the Financial Crime Commission Act was voted in 2023, Section 56, subsection 3, Mr. Deputy Speaker, sir, provides that, and I quote, where in the course of a criminal inquiry, the Commissioner of Police suspects that an offence under this Act or the Declaration of Asset Act has been, is being, or is likely to be committed, he shall, not he may, he shall, subject to subsection 4, refer the matter within 72 hours to the Commission, the FCC, for investigation. So here the word is shall. So as soon as the police found out that there is money laundering involved, he doesn't have any jurisdiction to continue investigation. The two exceptions is where there is an investigation in a fraud matter, the value of which is less than 500,000 rupees, or an investigation in financing of drug dealing, the value of which is less than 500,000 rupees. Why was that done? That was done purposely, Mr. Deputy Speaker, sir, in 2023, to take away powers from the police and give it to the FCC. Why? Because under the FCC law as voted then, the FCC could close the investigation and not refer it to the DPP. That was the reason why the power was withdrawn from the police and given to the FSC, so that they can hide, they can cover up everything, so that people like Franklin and others can be protected. Now that we are restoring the powers, now that we have restored the powers of the DPP, Mr. Deputy Speaker, sir, it is only natural that we should restore the power of the police to conduct an investigation in an offense which falls under the FCC Act, where it would be, that is the main caveat, where it would be in the interest of the efficient conduct of investigation that the police be allowed to conduct the inquiry either together with the FCC or alone, but in coordination with the FCC. Why is it important? It's important because the Honorable Adrien Duval himself said so. The FCC does not have the means, the financial means, which the police have. The FCC, when involving complex cases, involving cross-border transaction, involving investigation which require technologically sophisticated equipment and tracking devices, the police is better equipped than the FCC when you need to have cooperation with international crime-fighting agency. Again, the police have convention that they've tried, the treaty that they've signed, where it's easier to ask for collaboration in cross-border investigation if it is done by the police. For example, Scotland Yard. You know, if the police make a request for Scotland Yard, no problem. But if the FSC, if it is the FCC, then it has to do for a lot of diplomatic channel before they are able to get the assistance. So using the police is not only more efficient, but also more timely. That is why we're not saying that in all cases, the FCC will now ask the police to help. But there may be cases where the help of the police would be important. Mr. Deputy Speaker, sir, no single agency can tackle financial crime effectively if it acts alone. The FCC, with its mandate to investigate financial offences, brings specialized financial expertise and forensic capacity. However, the police, on the other hand, have broader investigatory authorities, more operational resources, and law enforcement reach. So together, it's not like competing. Together, they are complementing each other. And we needed to bring this amendment precisely because we did not want any suspect, when going to court, to argue that the police did not have authority to conduct investigation once there was an offense under the Act. Because as I have alluded previously, Mr. Deputy Speaker, sir, under Section 56, subsection 3, the police doesn't have a choice. He has to give up the inquiry if there is an offense suspected to have been committed under the Act, the value of which is more than 500,000 rupees. So in order to avoid any challenge by any suspect that the police was not entitled to investigate, that is why we're bringing in this piece of amendment to plug that loophole. Mr. Deputy Speaker, sir, the Honourable Adrien Duval, makes a big meal out of the fact that the parliamentary committee had not been consulted. Coming from a lawyer, a barrister, I'm very disappointed. Because the powers, the function, the role of the parliamentary committee is governed by the law, by the Financial Crime Commission, and under Section 131, the function and powers of the parliamentary committee are there. And they don't have any role in legislative drafting, in suggesting law for joint collaboration. It's beyond their mandate. And as Parliamentary Counsel, let me remind him what was going on when the MSM was in power. There was not even a quorum. Even the members of government was not attending that parliamentary committee. It was never sitting. And now today he's telling us, he's giving us lesson that we ought to have consulted the parliamentary committee. Mr. Deputy Speaker, sir, I will end by saying that allowing the police to conduct joint investigation with the FCC is in the interest of efficiency. And this will send a strong signal to the public, to the international community, to the criminal out there, that Mauritius is serious. Unlike the opposition, Mauritius, this government is serious about fighting financial crimes and, above all, doing what they were unable to do, which is securing conviction and recovering ill-gotten assets. Allowing proactive parallel financial investigation will also reassure FATF and our international partners that we are strengthening our AML CFT regime, and this will enhance our image as a serious, well-regulated financial center, which has been tainted, the image which has been tainted by the MSM government. Never again, Mr. Deputy Speaker, sir, should anyone ever point fingers at our jurisdiction. I'm done. Thank you.
Honourable Attorney General.
Mr. Deputy Speaker, sir, Each time I rise towards the end of speeches following a proposal to amend a law, I am as astounded as the last occasion by the lack of precision of the opposition in bringing out the true issues that need to be debated before this House. The leader of the opposition, Mr. Deputy Speaker, sir, has read paragraph 10 of the government programme. He read very well, but that is in contradistinction with his fellow colleague, the whip of the opposition, who seems to have completely forgotten to read the proposed amendments to be moved at committee stage, which led him to make a bit of a hash of his intervention, as already pointed out by the honourable member who has just spoken before me. Now, we have been served with expressions like crise institutionnelle, amateurisme, bras droit du Premier ministre, du déjà vu. All this from the leader of the opposition belies only one thing, is that the leader of the opposition's reading of these proposed amendments est, to use the language he likes to use, une lecture simpliste et biaisée pour des raisons bassement politiques. That the FCC Act is a despicable piece of legislation is a true statement. That the FCC Act will be repealed is also a truism. What we will do is to bring about a proper legislation, one which reflects our commitment to the rule of law, not what one wants to do in order to take control over things. And on the matter of control, Mr. Deputy Speaker, sir, the Honourable Whip of the Opposition is absolutely wrong when he says that there would be a potential conflict between the FCC and the Commissioner of Police. The Honourable Prime Minister has very clearly set out the scenarios which are capable of existing under the proposed amendments. And let me, at this stage, go back to what I had planned to say to this House this afternoon. This government, Mr. Deputy Speaker, sir, has repeatedly pledged that we shall leave no stone unturned in our commitment to strengthen our country's investigative capabilities, particularly against financial crimes. In previous debates, I have emphasized that ensuring a functional criminal justice system is a priority of ours, the aim being to reconcile the preservation of liberty and rights balanced with the imperatives of security and accountability. Today, we revisit these principles through the lens of cooperation between law enforcement entities. Why? Because it is important to remind ourselves that although institutions must operate independently, they must nevertheless act cohesively. Indeed, Mr. Deputy Speaker, sir, we must acknowledge that today's landscape of financial crimes is more complex than ever. As such, all criminal offences involving sums of money would at some stage also reveal aspects of money laundering or illicit financial flows. The interconnectedness demands, at the very least, cooperation between the police and the Financial Crime Commission. So far, we have witnessed, unfortunately, situations where parallel investigation by these two entities, though ostensibly addressing different offences, inevitably encroach upon the same set of facts. I myself, in my career, have argued a number of cases where the police were prosecuting an accused party under certain offences under the law, under the criminal code, whilst at the same time, before a different division of the intermediate court, criminal division, the same accused party on the same facts was being prosecuted under FIAMLA. This must stop, and this must be dealt with from the time of investigation. The overlap is, as my friend, the Minister Utim, early on said, is obvious in cases of drug trafficking, where separate investigations between ADSU and FCC can often lead to different results. A suspect may confess or collaborate with one entity whilst the other is left in the dark and its inquiry goes nowhere. The situation therefore creates duplicated efforts, wasteful expenditure, and ultimately judicial uncertainty. Our courts would only be able to eventually address such overlaps when there are seas of the matters, but even then, the procedural delays in determining whether two prosecutions relate to the same facts unnecessarily prolong legal uncertainty. And there is the possibility of contrasting, if not contradictory, judgments where one court would believe the FCC's case but not the case of the police, leading to a situation where the police is convicted of laundering the proceeds of crime but not convicted of the crime itself. At the same time, some criminal networks exploit those procedural gaps, ultimately undermining public trust and confidence in our justice system. The necessity, Mr. Deputy Speaker, sir, of joint and coordinated investigations between the FCC and the police is also a matter of international compliance. The Financial Action Task Force, in its Recommendation 30, calls upon countries to ensure, and I quote, designated law enforcement authorities have responsibility for money laundering and terrorist financing investigations within the framework of national AML-CFT policies. It specifically urges that in all cases related to major proceeds-generating offences, authorities should develop, and I quote, a proactive parallel financial investigation, and that this should cover cross-border predicate offences. Crucially, it also states that countries should use permanent or temporary multidisciplinary groups specialized in financial or asset investigations. In other words, the very structure of our law enforcement must reflect a capacity for institutions, such as the FCC and the police, to work jointly, swiftly, and effectively across jurisdictions and investigative trails. This bill represents a step towards that alignment. The proposed joint investigative mechanisms stands as a practical solution, allowing early-stage collaboration to avoid procedural pitfalls and ensure efficient use of resources. It respects the distinctive mandates of each entity, whilst acknowledging their intersection in the practical reality of complex investigations. The possibility of joint investigations, as outlined in the newly introduced Section 58A of the Financial Crimes Commission Act before this House today, allows for clearer, structured cooperation in three distinct scenarios. These three scenarios have been clearly spelled out by the Prime Minister in his address. There is no need for me to go over these again. The mechanisms provided in the new Section 58A is mindful of the inherent independence of the two agencies, and not as alleged that one would actually overstep on the authority of the other. Although the default position is the situation when both agencies agree to work together, the law provides for other possible situations. The imperative that can be culled from these amendments is one of efficient collaboration when the circumstances demand it. To summarize, if both FCC and police do not see the merit of a joint investigation, there will be none. If both decide that one is necessary, they are free to pool their efforts freely. But if ever one of them is of the opinion that a joint investigation is needed and the other agency is not so sure, the law will now command cooperation. Mr. Deputy Speaker, sir, the importance and urgency of these amendments are reflected in the fact that we are not waiting for the establishment of the new National Crime Agency to include them in our law enforcement arsenal. They reflect, n'en déplaise à certains, our broader vision articulated in the Government Programme 2529, which emphasizes modernizing and strengthening our justice system, fortifying our investigative frameworks, and renewing public trust in our law enforcement institutions. By embedding structured joint investigations in our law today, we are laying a strong foundation for the establishment of a fully functional national crime agency that will comprehensively address not just financial crimes, but all forms of serious and organized criminal activities. Indeed, the UK's National Crime Agency provides a compelling model showcasing the clear advantages of integrated investigative frameworks, collaborative policing, and strategic resource allocation. Our collaboration with the UK government, expected to run into 2026, will ensure Mauritius benefits fully from what has worked in the UK and the lessons learned there as well. Drawing from such international experience, our amendments today prepare Mauritian institutions to seamlessly evolve into a similarly powerful and effective entity from the outset. So, Deputy Speaker, sir, in our previous legislative amendments, notably to the Bail Act and the Financial Crimes Commission Act itself, we have consistently aimed to resolve ambiguity and clarify roles. Just as we sought to rectify the confusion between prosecutorial and investigative powers in the previous amendment to the FCC Act, so too do we today aim in reinforcing clarity. This government remains steadfastly committed to ensuring the rule of law remains the cornerstone of our democracy. Our institutions must be clear in their purpose, independent in their operations, and cooperative in their execution. In conclusion, Mr. Deputy Speaker, sir, these amendments are important to our commitment to securing a safe and prosperous future for Mauritius. They form the bedrock upon which we will build our future National Crime Agency, ensuring Mauritius remains vigilant and resilient against financial and organized crimes for many years to come. Mr. Deputy Speaker, sir, with these words, I commend the bill to the House.
Honourable Prime Minister.
Mr. Deputy Speaker, one voice. I sometimes despair that I have to answer these ridiculous things that they say. The Honourable Minister Rizautim, and just before me, the Attorney General, has responded so clearly why these amendments are being brought. The Leader of the Opposition said why we said in the program that the NCA will be made, it will be passed, the new law, and then 7 months. Honourable Rizautim quite rightly pointed out, they took 8 years to do what they said they would do. 8 years. And you're asking as far as why 7 months we haven't done it? In fact, we explained, already there are people from Scotland Yard who are helping us, police officers, investigative police officers. This is a transitional exercise that we're doing until the NCA is properly vetted and ready to be passed. I know that the other ridiculous thing was about the parliamentary committee. I think Honourable Utim Wright pointed out, since when do we pass legislation after consulting the parliamentary committee? It doesn't. Never. It has never happened. It's ridiculous. 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 You should have been here when he spoke. But you were not here. You should have been here when he spoke. He explained that properly for your benefit, because obviously you are ignorant of all this.
3 months ago. Read the
law. Read the law.
Order. Let's be set to the Honourable Prime Minister. Come on.
Yes. Honourable Juval said why the FCC was I will repeat what I said in a way. Everybody knows why the FCC was passed. Everybody knows, including your father, because you objected to it. It was not to intensify the combat against fraud or corruption or crimes, whatever. No, it was to protect those who the last government wanted to protect and to harass those they wanted to harass. That was the reason. That's the only reason. I'll give you an example. Did you know? You remember the former director of ICAC? He said one thing, and then he went to the public, to the Judicial Committee of the Privy Council on Medpoint, and said the other thing, contradicting ICAC itself. But where's the Honorable Adi Ajwa doesn't seem to know, or he's forgotten? Angus Road. You know what they did, the FCC? We had asked for mutual assistance. When they came to power, they wrote to the UK authorities to say they're cancelling the mutual demand for mutual assistance. They cancelled it for Angus Road so that there was no investigation was done because they knew what would have happened. That's what they did.
And you sit next to them.
Actually, we can't believe that this was done. And these are the very people who are now telling us what to do and what not to do. I despair, as I say, Mr. Deputy Speaker. Les rôles sont renversés. And they are, as the Attorney General said, they are missing the real issues. They're trying to do politics while missing the real issue. That is why I commend the bill to the House.
The question is that the Financial Crimes Commission Amendment Bill number 16 of 2025 be read a second time. Those in favor say aye. Aye. Those against say no. The ayes have it.
Committee stage.
Be seated.
Clause 1, short title. Clause 2, Section 56 of Principal Act amended. Clause 3, Section 58 of Principal Act amended.
The question is that clauses 1 to 3 stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
New Section 58A inserted in Principal Act.
Mr. Chairperson, I move that clause 4 be amended as per the amendment circulated.
The question is that clause 4 be amended as per amendment circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that clause 4 as amended stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Title enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that I do report to the House that the Financial Crimes Commission Amendment Bill number 16 of 2025 has passed the committee stage with amendment. Those in favor say aye. Aye. Those against say no. The ayes have it.
Yes.
Please be seated. Honorable members, I have to report to the House that the Financial Crimes Commission Amendment Bill number 16 of 2025 has passed the committee stage with amendment.
Third reading.
Mr. Deputy Speaker, I beg to move that the Financial Crimes Commission Amendment Bill number 16 of 2025 be read a third time and passed.
Seconded by the Deputy Prime Minister. The question is that the Financial Crimes Commission Amendment Bill number 16 of 2025 be read the third time and passed. Those in favor say aye. Those against say no. The ayes have it. Honorable Prime Minister.
Mr. Deputy Speaker, I beg to move for the adjournment of the House to Tuesday, the 22nd of July at 11:30 a.m.
The House stands adjourned.